today's your court hearing and you're ready to go, your attorney's ready to go. What should you expect at that court hearing? What should you expect how your attorney is going to represent you? Hi, my name is attorney Anthony Spratley. I'm the owner and founder of Genus Law Group here in Albuquerque, New Mexico, where we practice family law, which includes like custody and divorce law throughout the state of New Mexico. Now, you're in front of the judge and your case is ready to go, and your judge calls the case to order and you're ready to proceed. And let's say you didn't file the motion and the other party did. So what happens next? So usually the other attorney, the attorney or the client or the party that filed the motion, they get to go first, right? They get to tell their side of the story. Now, usually that hearing is 30 minutes, but sometimes it's an hour. So just think about it. 30 minutes or an hour to decide whatever issue that you have before the court. It's not a lot of time. And so usually the person that goes first, they're going to get more time. Now, a lot of judges, most judges keep track of the time to give everyone equal time, but really the burden is on the person that filed the motion to prove their case, right? They have to show the court why their motion should be granted so that they can get a certain type of relief that's favorable to them. Now, what typically happens? That attorney gets up if they're represented and they start asking questions of their first witness. And usually the first witness is the person who wanted the motion filed, right? The other party, either your ex-spouse or the mother or father of your child. And they're going to start asking them direct questions about their case. Now, you're going to sit there and you're going to listen to this testimony. And what I normally do for my clients, I give them a sheet of paper so they can write down any questions that they may have based on the testimony of the other party, right? It gives them something to do, because I can't get an elbow to the side, or I can't get a whisper to the ear, or now since we're doing it over the telephone, I can't get a chat over our Google Meets to pay attention. I can't pay attention to it because I have to pay attention to the testimony, right? And so you need to understand that I'm listening, because as the attorney is listening to the testimony, it's actually helping you out in your case. Now, you're going to hear some testimony from that witness under oath, and they're going to sound like a barrage of lies probably. And hopefully you're not going to be huffing and puffing about everything that they're saying. If you're in court, you're not rolling your eyes, because the court, they hear and they see those things as well. But understand that your attorney who's representing you is listening. And then after that attorney does their direct examination of their witness, and I get the opportunity, or if you're representing yourself, you get the opportunity to cross-examine that witness and then get additional facts from that person, right? To challenge some of the assertions that were made during their testimony. That's why it's very, very important to leave your attorney alone, or if you're representing yourself, to pay very, very close attention to what that person is saying, because it could make or break your case. Now, after they finish their case, then you have the opportunity to put on your case. And so if you're represented by attorney, they'll put you on the stand, the judge will swear you in under oath, and that attorney will start asking you questions about your case. And if there's evidence that you want to present, I'm not talking about 300 pages of text messages. Remember, the court, if we have 30 minutes, there's no way we're going to get 300 pages of text messages in, right? It's just unrealistic, or 30 minutes of video or audio, right? You need to stick to the facts and to what's relevant. So your attorney is going to get you on the stand, going to ask you some questions, right, to help you defend yourself essentially, because that's what you're doing in this case and why the court should not grant that motion, and perhaps give you some relief. But after that attorney gets those facts out of you, then the other attorney is going to conduct their cross-examination, and they're going to try to trip you up in their cross-examination of you and put out their story that they want the judge to hear. Now, after the judge hears testimony from the movement in the case, that's the person who filed the motion, and then from the respondent, then the court is going to make a decision. And based on that decision, you're either going to have to live with it, file a motion to reconsider with the court, or you can appeal it, right? So, getting ready for hearings is very, very important. You need to be involved in that process and getting your attorney ready. being involved in a hearing, being very cognizant of the fact that your attorney is listening and advocating on your behalf when it comes to what the other party is saying, and getting you to say certain things that help out your case. And then, understand that your attorney cannot control what the other party is saying on the stand. They can't. Even under cross-examination, the goal for me is to get the other party to admit to certain things that I believe will help your case. And they may deny the questions that I ask them, and you might huff and puff based on their answers because you believe that they're lying. I can't control what they say. I can't control what they say on direct examination. We're gonna have to live with the answers that they give. You're gonna have to live with the answers that they give, and then you gotta let the judge decide, whether or not they believe that person or not. And just one final thing, I know oftentimes there's just so much information, so many things that are going on during a hearing, and attorneys are doing the best they can do. And sometimes, as a client, you have the benefit of sitting there knowing in your head exactly the questions that you want to ask, right? Most attorneys will, before they end their direct or their cross-examination, they'll go to their client and say, is there anything else? And then there may be that one last question that you want them to ask. But if your attorney doesn't ask a question, it's not because they don't care about your case, but perhaps it wasn't relevant to your case. Because sometimes the best question asked is one that isn't asked, right? There have been times in court when the client insisted that I asked a question, and the client gets to say where it actually hurt their case, right? It actually hurt their case. And so just understand and appreciate that your attorney is doing the best that they can do to advocate zealously for your position, and that perhaps they're not going to think of everything, but they are prepared and ready to represent you zealously in court. All right, folks, I know that was a little bit long. A lot of people are nervous when it comes to a court hearing. If you find yourself getting nervous about the next steps in your hearing, and say you have an attorney or you don't have one yet, you need to reach out to one so you can figure out what to expect during the hearing, or you can watch this video. All right, that's all I have for today. If you want more content about family law issues, maybe one that you're interested in, go to www.genuslawgrp.com. You can also go to our Protect Your Success podcast at Apple Podcasts. All right, have a great day.